The U.S. Supreme Court has begun its new term, agreeing to hear cases covering LGBTQ plus rights, as well as voting rights. The High Court this week heard arguments in a case out of Colorado brought on by a Christian therapist who argues the state's ban on conversion therapy violates her First Amendment rights. Conversion therapy is favored among some religious conservatives as a way to force minors to identify as heterosexual and transgender children to identify as the gender identities assigned to them at birth. Justices are also set to hear arguments next week in a case challenging Louisiana's congressional map. That case could ultimately reshape the Voting Rights Act. And joining us live tonight to discuss is Assistant Law Professor Erin Carr from Seattle University. Erin, thanks so much for being with us.
Good evening, Joyce.
Let's start with the Colorado gay conversion therapy case. What is at stake for LGBTQ plus rights beyond Colorado's borders?
So this decision could have reverberations across the country. Last term, and again with the beginning of the new Supreme Court term this past week, the court has shown a keen interest in LGBTQ plus issues. Just this past June, in a case called Skirmetti, the Supreme Court upheld a ban on gender-affirming care in determining that states should be given deference in determining gender transition health care for minors. But now, in the most recent case before the Supreme Court, the court appears poised to strike down a Colorado law that bars mental health professionals from providing therapy targeted at changing the sexual orientation or gender identity of minors. This is a case that was brought by an evangelical therapist who claims that the Colorado law violates her First Amendment rights because the treatment that she provides, in her view, takes the form of speech. Now, if the court were to agree with that characterization and conclude that the state conversion therapy ban does, in fact, unconstitutionally infringe upon the therapist's speech rights, as a majority of the justices appear inclined to do based on this week's oral arguments, it would have the effect of not only invalidating the Colorado law at issue, but would upend similar laws that are in effect in half of the country.
So then, how does this test the boundaries between free speech and public health regulation?
The central legal question before the court is whether therapy should be viewed as constitutionally protected speech, or whether therapeutic treatment is conduct that can be subject to reasonable government regulation. If the court ultimately decides that this case implicates constitutionally protected speech rather than therapeutic treatment, it will apply an elevated standard of judicial review known as strict scrutiny that will be fatalistic to the Colorado law. And so consequently, if the speech of healthcare providers is afforded these heightened constitutional protections, laws that attempt or try to limit substandard healthcare or medical treatment that experts agree is unsafe or ineffective could be subject to legal challenges that would be very, very difficult to defend.
Let's talk now about the Louisiana case that could impact the Voting Rights Act. Tell us what's at stake with this.
So this particular case centers around whether the creation of a majority-minority congressional district violates the 14th and 15th Amendments of the Constitution, which were enacted in part to prohibit racial discrimination in voting rights. In 1965, Congress further codified the 14th and 15th Amendments in the Voting Rights Act, a crown achievement of the civil rights movement that was intended to end legalized discriminatory voting practices that had persisted for generations. The majority-minority congressional district in this case was required after several federal courts concluded that the Louisiana state legislature, over a period of multiple elections, had engaged in illegal racial discrimination to dilute the voting power of minority voters. Now, what's interesting about this case is it actually came before the court last term. However, at the end of the last term, the court decided not to resolve the case, instead setting it for rehearing this term and requesting that the parties address a much broader legal question than the case originally presented. Essentially, whether creating these majority minority districts, such as the one in Louisiana, in order to comply with the Voting Rights Act, is itself unconstitutional. And the fact that the court directed the parties to brief this question does not bode well for the fate of the Voting Rights Act and suggests that the court may be primed to gut the final remaining pillars of this landmark civil rights statute.
Which, as you point out, was within our lifetime. So at least mine, not yours, but mine for sure.
Also mine. No.
Erin Card, thank you so much for being with us from Seattle University. We appreciate it.
Enjoy your weekend, Joyce.